for delivery of judgment, item numbers 1 and 2.
Both the writ petition dismissed.
Obligolus.
Please, Your Lordship.
Yes.
Lordship, I beg to mention item 20. Lordship, kindly grant me a further time of 2 weeks to file my counter. I'm for the state correspondence.
You inform the other side? Yes.
Yes.
Any objection? No objection. Miss, your good name, please.
S. Maria.
Learned government advocate.
Yes, Your Lordship.
Submits that she may be granted 2 weeks time to
weeks' time.
file counter affidavit. The learned counsel for the petitioner submits that she has no objection. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that recess shall list the matter after 2 weeks.
I'm obliged.
May I please, my lord?
Yes.
Lordship, I beg to mention item 26 to 29. Hearing item 26 to 29, Your Lordship, if this matter can be listed after 2 weeks, my lord.
Why?
Your Lordship, in fact, I have some personal difficulties today. I have one review method fixed in report number 2, Your Lordship. Not only that, Your Lordship, this matter will consume some time.
Pardon?
It will consume some time, Your Lordship.
So what?
So, Your Lordship, if the review is heard, Your Lordship, I may not be able to submit on my this thing.
Okay.
If it can be listed after 2 weeks, my lord.
Yes. Any objection?
No objection.
Mr. So-and-so, learned government advocate. Mr. Mozo, you are for?
I'm for respondent number 7.
Respondent number 7. Submits that the matter may be listed after
2 weeks, my lord.
2 weeks. After 2 weeks, the learned counsel for the petitioner submits that she has no objection. Mr. Mozo, learned counsel for the respondent number 7.
7.
Respondent number 7 present. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that recess shall list the matter after 2 weeks.
Oh, Lordship, there is some interim.
Interim in all the matters.
Yes, no.
Okay. Interim order pass earlier self-containing.
Last question.
May I please, Your Lordship?
Yes.
Lordship, I beg to mention item number 9. Here I'm sent for waiting, so kindly grant me 3 weeks of time to file my complaint. Item number 9. Listen, waiting, Lordship.
Your good name, please?
Ajuli, Lordship.
Azuli.
Lordship.
But on the other day, you have submitted before the court that during the course of the day, you will be filing your counter
Yes,
affidavit.
Lordship. There was some clerical error, so they sent me back and I've sent during my vacation, Lordship.
Is it?
Lordship. I have received that day through the postman, but there was some clerical error, Lordship. That's what.
Mr. So-and-so learned counsel, state counsel for the state respondent submits that he may be granted 2 weeks time
Lordship.
to file the counter affidavit. He also submits that though there was a direction to submit the counter affidavit during the course of the day on the earlier occasion, the same could not be filed on account of some clerical errors. And as such, he pressed for listing the matter after 2 weeks. Any objection, madam?
I have no objection.
The learned counsel for the petitioner submits that he has no objection. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that recess shall list the matter after 2 weeks. And in the meantime, learned government advocate shall file the affidavit in counter affidavit. Okay.
Lordship, similar prayer, item number 17. Lordship, here I'm here to receive instruction, so kindly grant me 3 weeks. Item 17, Lordship.
Okay. Mr. So-and-so. Anybody for the petitioner? No.
I have take consent, Lordship.
Mr. So learned government advocate with consent from the other side, press for listening the matter after
3 weeks, Lordship.
3 weeks, as he has not received any instruction from the respondent authorities. Any objection?
No objection, Lordship.
Mr. Walling, learned counsel for the petitioner submits that he has no objection. Accordingly, it is provided that recess shall list the matter after 2 weeks.
3 weeks, Lordship.
3 weeks.
Lordship, I beg to mention item number then, behalf of additional AG. Here we are yet to receive instruction.
Item
So-
number
Then, Lordship.
10.
Lordship. Here we are yet to receive instruction, so kindly grant 3 weeks of time.
So,
And for the petitioner, I have no objection.
no objection. Mr. So learned government advocate appearing on behalf of Mr.
Additional AG in Dim Sum.
I am some learned additional lazy. Press for listing the matter after
3 weeks, Lordship.
as he has not received any instruction from the respondent authorities. The learned counsel for the petitioner submits that he has no objection. Accordingly, it is provided that recess shall list the matter after 3 weeks.
I'm appearing for respondent number 5. This is my first appearance. I'll be filing my Bagatama.
Okay, Mr. So learned counsel entered appearance for the respondent number 5, and he will be filing his Ukaladnama during the course of the day.
Wait, please, Your Lordship. I beg to mention hearing item number 30 and 31 on behalf of Mr. L. Irano. He has difficulty today.
30 and 31.
Hearing. I've
Yes.
taken the consent of the for the part.
Any objection?
I agree that this matter may be fixed on 19th of February.
19th February. Ms. So learned counsel appearing on behalf of Mr.
L. Iralo for the private respondent.
L. Iralo, learned counsel for the private respondent. Press for listing the matter after on 19th of February. The learned counsel for the petitioner submits that he has no objection. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that recess shall list the matter on 19th of February 2026.
We have this, Lordship. Lordship, I beg to mention item number 5, 6, 7, and 8, Lordship. Your Lordship, I have received the instructions, Lordship. So if sometime you be granted to me, Lordship. I have received the instructions.
Okay, Miss
Miss S. Jung.
S. Sang, learned government advocate, submits that she has received instruction from the respondent authorities and she may be granted some time to file counter affidavit. Madam, any objection?
Lordship, I have no objection.
Miss, your good name, please.
Grace Namgi.
Learned counsel for the petitioner submits that she has no objection. Accordingly, it is provided that recess shall list the matter after
3 weeks, Lordship.
3 weeks.
Lordship, I have seen the prayer for item 11, Lordship.
Okay, similar order. Here you have
I've received instructions.
instruction.
Yes, Lordship.
And she may be granted some time to file affidavit in opposition. And Mr. Walling, learned counsel for the petitioner submits that no objection. Accordingly, it is provided that recess shall list the matter after
After 3 weeks, Lordship.
after 3 weeks. And in the meantime, learned government advocate shall file counter affidavit.
Lordship, I have seen the prayer for item 18, Lordship. On behalf of my colleague, Pichano.
Ms. Sang, learned counsel, learned government advocate appearing on behalf of Miss
Miss Pichano.
learned government advocate. With consent from the other side, press for listing the matter after 2 weeks or 3 weeks.
3 weeks, Lordship.
After 3 weeks. Parallel.
Lordship, I also like to mention item number 16, Lordship.
Lordship, the other day also, it was because of them, it was not listed, and now today also they are mentioning. The other day also, it is. It is.
No,
they-
madam,
the
you
Lordship-
say, in
I
this
have
matter,
instructions, Lordship, as of now, Lordship. So if sometime may be granted to me, Lordship.
Lordship, this
no,
is
no,
regard to
what
the-
instruction is necessary here? Because
Yes.
law is well settled. And the state government has also issued one notification.
Yes, it's their
So
own
based on the
notification.
decision of the Supreme Court and also on the basis of the OM issued by the government, the matter can be disposed of.
Lordship, if a short time may be given to me, Lordship,
Why short time is necessary?
I want to get the instructions, Lordship.
What instruction is
proper-
necessary?
With the proper instructions, Lordship, I cannot go. else.
So we'll take this matter at 2 o'clock. Take up this matter at 2 o'clock. You, in the meantime, you obtain instruction
Lordship,
at 2 o'clock.
Lordship.
oblige, Lordship.
Oh, Lordship.
Wait, please, Your Lordship. Lordship, I beg to mention hearing item 37 and 38, Lordship. Here, I'm for the respondent number 4, Lordship. My senior counsel Ajo is currently out of station because of his daughter's treatment. So I pray Your Lordship may humbly list this matter up.
Mr. Your name, please.
Vic was our
He Koza, learned counsel appearing on behalf of
respondent 4,
respondent number 4 submits that conducting counsel Mr.
Ajo,
is out of station.
Lordship.
Out of station. And as such, the matter may be listed after
3 weeks, Lordship.
3 weeks. Any objection? The learned counsel for the petitioner submits that she has no objection. Accordingly, it is provided that SSL is the matter after
3 weeks.
3 weeks.
Lordship, there's an interim.
Interim order pass earlier shall continue. Okay.
Okay, please, Lordship. Lordship, I have a similar prayer for item 3. Here for private respondent number 5. Lordship, the pleadings are completed here, Lordship.
Yes, and the matter is listed in the admission column.
Lordship, Lord.
Any objection?
No.
No. Mr. So-and-so, learned counsel, appearing on behalf of
Respondent number 5, Lordship.
respondent number 5. Your name is not there.
Lordship, no, Lordship. On behalf of Ajo, Lordship.
Appearing on behalf of Mr. So-and-so. Learned conducting counsel for the respondent number 5 submits that the matter may be listed after
3 weeks, Lordship.
3 weeks. The learned counsel for the petitioner submits that he has no objection. Accordingly, it is provided that SSL is the matter after 3 weeks.
Lordship, Lordship.
May I please, madam? Lordship, I beg to mention item 12 and 30 on behalf of my colleague K. Angami, Lordship. He is indisposed today. If this matter can be listed after 3 weeks.
So,
madam.
learned counsel appearing on behalf of Mr. K. Angami, learned government advocate.
Yes, madam.
You inform the other side?
Lordship, I have been informed that they have discussed over the phone, my lord.
Okay. With consent from the other side, press for listing the matter after
3 weeks, madam.
3 weeks. Fair allowed.
I am deeply obliged, madam.
Please, Your Lordship, I'm pleased to mention hearing item number 33 on behalf of AIME. She is indisposed, Your Lordship. Your Lordship, let the matter come up after 3 weeks, Your Lordship. Item 33, Your Lordship.
Ms. So-and-so, learned counsel appearing on behalf of
AIME, Your Lordship. She is not well.
learned government advocate with consent from the other side, press for listing the matter after
3 weeks, Your Lordship.
3 weeks. Fair allowed.
Your Lordship, similar prayer for 34 and 36 also on behalf of AIM. 34
Okay. Similar order.
and 36. Your Lordship, I also best mention item number 21. Your Lordship, 3 weeks may be granted for filing my affidavit, Your Lordship. I need to receive instruction.
2 weeks.
3 weeks, Your Lordship.
3 weeks.
Participation in train, can you continue?
Okay.
What you might call respondent number 6 and 7.
Respondent number 6 and 7.
Give a direct strictly rule. Also include my name there.
Pardon?
Cost list.
Pardon?
My name the cost list.
Okay. Okay.
As for respondent.
Heard Mr. Fosiko Patel, learned counsel for the petitioner, and Mr.
W.
learned counsel for the respondent number
6 and 7.
respondent number 6 and 7, and Miss Levika, learned government advocate appearing on behalf of
For the state 1 to 5.
respondent number 1 to 5. So why you are praying for adjournment?
Your Lordship, I need to refuse instruction, Your Lordship. The hard copy I need to
Ms.
receive.
Levika submits that she has not received instruction and she pays for listing the matter after
3 weeks.
3 weeks so as to enable her to file counter affidavit. Mr. Pote submits that he has no objection. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that recess shall list the matter after 3 weeks. The learned counsel for the respondent number 6 and 7 submits that his name has not been reflected in the cause list. Recess shall do the needful in this regard.
Which is the interim.
Interim order passed earlier shall continue.
Lordship, I also like to mention item number 22 on behalf of Ina Holly. Your Lordship, if this matter can come up after 2 weeks, Your Lordship, for placing necessary instruction, Your Lordship.
Ms. Levika, learned counsel appearing on behalf of Ms. Ina Holly, learned government advocate, submits that the matter may be listed after
2
2
weeks.
weeks so as to enable her to obtain inspection and to place the same before this court. Mr. Zamir, learned counsel for the petitioner, submits that. Any objection?
No.
Submits that he has no objection. Accordingly, it's provided that recess shall list the matter after 2 weeks. After 2
Much
weeks.
appreciated.
Please, Your Lordship, I'd like to mention item number 15. 3 weeks time will be pending to file my affidavit in opposition.
You
I'm
are
for respondent number 4.
respondent number 4. Mr.
Nang Sangayer.
Learned counsel appearing for the respondent number 4 submits that he may be granted
3 weeks time.
3 weeks time to file
Affidavit in opposition.
affidavit in opposition. Any objection?
No objection.
The learned counsel for the petitioner submits that she has no objection. Accordingly, it is provided that recess shall list the matter after 3 weeks.
Lordship, there is an interim.
Interim order passed earlier shall continue.
Yeah, please, the Lordship.
Yes.
I'd like to mention item number 19. Lordship, here I'm for respondent number 1 to 8. Lordship, I'm allowed 3 weeks time to find my affidavit.
Mr. So learned counsel for the learned government advocate for the respondent number 1 to 8 submits that he may be granted
3 weeks time.
3 weeks time to file counter affidavit. Mr. Walling, learned counsel for the petitioner, submits that he has no objection. Mr. Seki, you offer?
Your Lordship, I'm for respondent number 9.
Mr.
AG.
Seki for respondent number 9. List the matter after 3 weeks. 3 weeks.
My lord, may I be permitted to mention a matter?
Yes.
My lord, item number 12.
Yes.
In this matter, my lord, I'm appearing on behalf of the petitioner. Now, the petitioner expired on 12th of January. Now, today was fixed for filing the reply in respect of the affidavit of opposition that has been submitted by the state, the respondents. Now, my lord, he wants to be he would be substituted by his legal heirs, being his wife and son. But we are yet to get the death certificate of this petitioner. So I require some time to file the substitution petitioner, my lord.
No, the state council has already mentioned the matter, both the matter.
Okay, my lord.
Okay. Later on. Mr. Your good name, please.
Mohammed Shamimuddin, my lord.
Mohammed Jamiuddin, learned
Shamimuddin, my lord.
counsel for the petitioner submits that the petitioner here in in both the petitions suffered demise, and his wife and his son, being the legal heirs, are required to be implemented as petitioner in these petitions, and he has not yet received the death certificate of the petitioner, and accordingly he prays for listing the matter after. Now, accordingly, he prays for granting him some time. It is to be noted here that the learned state council has already mentioned the matter and granted 2 weeks or 3 weeks. So we have granted
3 weeks.
3 weeks. 3 weeks. Okay. It's like 3 weeks will be sufficient.
Yes, my lord, 3 weeks will be sufficient.
Accordingly, it is provided that SSL is the matter after 3 weeks.
Much of.
May it please the court, your lordship, I beg to mention item number 14 on behalf of my senior, Gauhati, learned CGC. Your lordship, we are yet to receive instruction in this matter, so if this matter can kindly come up after 3 weeks.
Mr. Your name, please.
Masilezo Rote.
Learned counsel appearing on behalf of Mr. Yangarati, learned CGSC, submits that the learned CGSC has not received any instruction, and as such, the matter may be listed after 3 weeks. Mr. Forte, learned counsel for the petitioner. Any objection?
No, Lord.
Submits that he has no objection in the event of granting 3 weeks time to the learned CGSC. Accordingly, it is provided that SSL is the matter after 3 weeks.
Right, your lordship.
If I may please, your lordship, I beg to mention item number 35.
Item number 35.
Your lordship, taking concern from the other parties, I beg, kindly adjourn the matter on to date 9 of February of next month.
9th of February.
Yes, your lordship.
Mr. Your name, please?
I'm standing on behalf of my senior El Irala, Mr. Meto Cafe.
El Iralo.
Yes, your honor.
Mr. So-and-so, learned counsel appearing on behalf of Mr. El Iralo. Learned counsel for the respondent number.
All the private respondent.
All the private respondent. With consent from the other side, first for listing the matter after.
Lordship, if the lordship may please to fix the date, it's on 9 or 10 of February.
9. On 9th of February. 9th of February. Accordingly, taking note of the submission of learned counsel for the respondent, it is provided that SSL lays the matter on 9th of February.
For motion, item number 1.
May it please the Lord. My lord, the matter seems to be very empty. But my lord, today, my lord, my submission would be, the lordship will find how the state machinery is exploiting these poor villages. Lord, when this honorable court has already held that they are entitled to get the compensation. And that compensation in the meantime, my lord, we have received only in the last of 2024 and the initial part of 2025. But then without any interest and solution, which is under the law, they are entitled. Well, we have come for that purpose only. Now, today, my lord, instead of arguing the whole matter, it will also issue notice to the parties. Well, I don't know, CGSC is supposed to have come, we have already served notice to them, but none of the lawyers, this has shown their name also.
But Mr. Dotto, you see,
My lord.
in the PIL, there was a pair
Yes,
for granting interest.
my lord.
And while disposing of the said PIL, no interest was granted to you.
My lord, your lordship,
Now, can you again re-agitate the matter whether you will not be barred
My lord,
by the res judicata?
my lord, on that, my submission would be, when this honorable court passed an order to pay compensation, my lord, I will take your lordship to plethora of decision of the honorable appeals court. The lordship is if compensation includes interest and solatium. Even if your lordship look at the statute, relevant statute like National Highways Act, then Land Regulation Act 1894, and then 2013.
No.
All these
Mr. Dotto, you see, here your land is not acquired by the government.
right, your lordship is very
Under any of the act,
right.
either under 13 Act or the earlier act.
Exactly.
So solatium will come from who is under which legal
Now,
framework?
yes, a very valid question. Now, my answer will be, my lord, I will take your lordship the decision of the appeals court were within 2020, their lordship is see, if you do not acquire, but some other parts of the same area you are acquiring for the road, well, they have acquired. Now below the road, those land were for someone's land for building, then the paddy field, the irrigation field, all these things. And these were permanently destroyed. Then the Honorable Appeals Court say by taking a deeming provision, you have to acquire it and pay their compensation like the way you have paid to those persons whose land has been used for the road purpose. Now, therefore, that decision exactly covers this case. So, therefore, what I am proposing, let the entire matter be heard, and my lord, at the threshold it can be decided.
No, why the res judicata will not be applicable here?
My lord, the res judicata will not be appealed because the pure question of law. When the pure question of law and the compensation is construed to be including interest and solatium, then my lord, this concept of res judicata will not come. And the pertinent part of the thing, my lord, we could not come earlier because of my lord financial constraint and all that. It was their pose were grievances were exposed.
No, you have already received the compensation.
Yes.
Then how can you make such a plea?
My lord, that plea, that's the reason I'm saying. My lord, the appeals court has time and again is saying that it includes interest and solatium. And my lord, it is bounden duty of the state. They ought to have, my lord, taken the aid of the statute.
No, for solatium, there was no payer in the PIL.
My lord,
Only payer was the interest.
my lord, essentially, my lord,
When the matter was adjudicated by the division bench in PIL.
No, my lord, your lordship will find. Essentially, when you acquire, my lord, the state has to acquire the land in terms of the statute. But here your lordship will find, possibly, my lord, the state or the central government can say precisely. Now, they did not take aid of any of the statute. My lord, can they do it? Even now, my lord, this is a continuous cause of action. Even now, the honorable court can take into account. If you did not take into account any of the statute in consideration, that means you have deprived those people.
No. Statutory construction means under which statute you have filed a claim?
My lord, actually, they ought to have taken the National Highways Act.
But nowhere you have mentioned it.
No, the state did not go for that. They did not acquire. They did not take into consideration any statement. I do not know how they can do it. Now, if you fail to take aid of any statement, means you are depriving the citizen of the country. And they are poor agriculturists, and you should also understand India.
No, that's all right. But where you have mentioned in the petition that it is filed under the National Highway Act.
No, I am not saying that. I am saying that they did not take aid of any of the state. Now, when you acquire the land without the aid of the state, entire machineries has done the thing quite illegally. Because the compensation is ought to be given. Your lordship, they take the aid of National Highways Act, then solatium itself will have to be 100%. Whatever the compensation they are giving, it will be double to that extent. Plus interest at the rate of 9% or 15% as the case may be. So these are the things to be taken into account. And the state is
today the State Council is absent.
Yes, I
without hearing the other side.
CGSC, they ought to have been there.
But the question is,
well, that what your lordship is asking for, that can be taken into account. The lordship may issue notice also. Let them appear and let the matter be heard. Because the matter is very important.
No, had it been a fresh matter, then we would have issued notice without hearing them. But let it be fixed on day after tomorrow. In the meantime, the learned CGC may turn up.
Well, your lordship may, in that case, My lord, your lordship can do one thing. Your lordship may issue the notice keeping the maintainability point off. That also can be done.
But there's a maintainability point.
Yes, yes, that your lordship can hear. They can, my lord, whatever they want to say on that one, they can, you know, enlighten your lordship also. CGSC ought to have been there because their name reflects in the process.
Better we must heard the CGC before issuing notice.
CGSC, since CGSC is not there.
There is a delay also in approaching this court.
My lord,
Several issues are there.
my lord, we have come to the 25 itself. And the payment has been made on early 2025.
Even then, now we are in 26.
My lord, but my lord, I'll take your lordship a decision. If it is a continuous cause of action, this.
No, that's all right. In case of continuous cause of action, this question of limitation does not arise.
Yes.
But
That's the 2020, the appeals court is saying.
so let it be day after tomorrow. The court master will inform the CGC.
Because my lord, the next week I'll be out of station. Out of station means my lord, I'll be.
No, that's all right. You can appear from principal seat
No,
through
I'll be-
BC.
I'll be at Calcutta, my lord. My brother is not keeping well. So even I have to go on there, but because of this case, I. You know, sometimes in the middle of February, something like that. You may tell us also. No, 16 February, can you look to accommodate?
16.
16.
Okay, all right. Heard Mr. Dotto, learned senior counsel assisted by Mr. A. Sharma, learned counsel for the petitioner. None appears for the respondent number. CGC is the respondent number.
So the respondent number 1.
None appears for the respondent number 1, 2, 3, and 4. And anybody for state of Nagaland?
No, my lord.
We haven't received the
Copy, notice.
No copy.
You go for the 5, 6, and 7.
My lord, we haven't received any such copy.
Well, that will provide you 5, 6, and 7.
5, 6, and 7. Mr. Your name, please?
LB Sankar.
Learned. Additional is for the respondent number 5, 6, and 7. The learned additional lazy submits that he has not been furnished with a copy of the petition and also the notice. Mr. Dotto, learned counsel for the petitioner, submits that he will furnish the same to the learned additional lazy during the course of the day.
By tomorrow, my lord, the very bulky.
By tomorrow. This petition under Article 226 of the Constitution of India, the petitioners altogether 919 in numbers have applied for issuing direction to the respondent authorities to declare that the petitioners are entitled to receive adequate interest to be calculated from the year 2012, within bracket actual years of damage, for the delayed release of the compensation in the year 2024, that's 2025, and also solatium for permanent nature of loss, for the permanent nature of loss to the properties, land and farm, and also to direct the respondent authorities to pay adequate interest to be calculated from the year 2012 for the delayed release of the compensation in the month of in the year of 2024, that's 2025, and also solatium for the permanent nature of loss to their properties, land and farm. In view of the issue involved in this petition, before issuing notice to the respondent authorities, hearing of the learned CGSC and also the learned additional AG is found to be necessary, and accordingly found to be necessary, especially on the point of res judicata, and accordingly it is provided that the SSL is the matter on
16th of February.
16th of February. 16th of February.
For motion, item number 2.
Please, Your Lordship. Your Lordship, during the COVID-19, the state adopted a policy for favoring the health workers who have performed at least 100 days or more during the COVID-19 for a special recruitment drive. The only category that has been left out are the petitioners, who are the TrueNet lab technicians, Your Lordship. So, my Lord, when there has been a standing policy for all the healthcare workers all over the country, and the state has also adopted the same policy, we have been left out. Hence, we are approaching this own court for inclusion as part of the SRD, Your Lordship. We separately conducted for the petitioners category, the TrueNet lab technicians, my Lord. My Lord, the qualifying number of days to be considered for special recruitment drive was 100 days. In the case of the petitioners, the minimum days performed is 265 days to 563 days, Your Lordship. So, my Lord, the BSL lab technicians, BSL that requires a higher specialized qualification, Your Lordship. There were 6 posts advertised during the peak of the COVID-19 period in the month of August 2020. There are 6 posts that was advertised for the BSL lab technicians. They were included in the SRD, but we have no grievance against them because their qualification is different. As far as the petitioners are concerned, they are TrueNet lab technicians. They have equally risked their lives in the most dangerous situation, the pandemic situation that the world faced. Now, once the policy has come to fruition, the petitioners category have been left out. Hence, we are approaching this own court, my Lord.
Yes, anybody for the respondents? You.
Notice, Your Lordship. Notice.
Notice.
Yes, Lordship.
Good. Heard Mrs. Joshua Saki, learned counsel for the petitioner, and Ms. Hassan, learned government advocate for the state respondent. In this petition under Article 226 of the Constitution of India, the petitioners altogether 18 number.
My Lord, 8.
18 number.
8 petitioners
have prayed for issuing direction to the respondent authorities to constitute a separate special recruitment drive to regularize the service of the petitioners by applying the same yardstick that has been applied to the healthcare workers who perform COVID-19 duties. And also to direct the respondent authorities to conduct the SRD for the petitioners from within the available 30 laboratory technician post vacancies. And also to direct the respondent authorities to regularize their services with effect from the date of filing of the present writ petition with all consequential benefit. Mr. Seki Learned Counsel for the petitioner submits that the petitioners were appointed as temporary laboratory technician
My lord.
and they have been working where they are presently where they are working
Lordship, presently they're working under Naga Hospital Authority, Kohima.
and presently they are working at Naga Hospital Authority Kohima as temporary on temporary contingency basis. Mr. Second Learned Counsel for the petitioner further submits that the petitioners have rendered their service for more than 100 years during the period of COVID. And after the period of COVID, the government has taken a policy decision to regularize the services of the health workers who have rendered 100 days service during the COVID period. But unfortunately, the present petitioners have been left out from being regularized under the said policy decision. And being aggrieved, the petitioners approach this court by filing the present petition. Ms. Sang Learned, government advocate for the respondent authority submits that at this basis notice may be issued. But having heard the submission of Learned Counsel for both the parties, I have carefully gone through the petition and the documents placed on record. Let notice be issued to the respondents returnable in 4 weeks. However, no formal notice is required to be issued since Ms. Sang entered appearance and received notice. However, extra requisite copy of the petition be furnished to her during the course of the day. I'll list the matter after 4 weeks. In the meantime, Ms. Sang shall obtain necessary instruction and file her counter affidavit after 4 weeks.
For admission, item number 4.
Yeah, this Lordship. I beg to mention on behalf of my colleague Lordship, if 3 weeks time you granted to me, Lordship.
For
I'm yet to receive instructions, Lordship.
heard, Mr.
I'm Pakiritabu.
Learned Counsel for the petitioner and Ms. S. Sang, Learned Government Advocate, appearing on behalf of Mr.
N. Langkumar.
Mr. N. Langkumar, Learned Government Advocate. Ms. Sang submits that Mr. Langkumar has not received any instruction from the respondent authorities, and as such, some time may be granted to obtain instruction and to file the affidavit in opposition. They are allowed to receive at least the matter after
3 weeks.
3 weeks.
Much obliged.
For orders, item number 23.
Lordship, this morning I've been informed by the Council of the Council for the Petitioner that they will be closing the petitions.
Petitioner?
They will be closing the petition The petitioner was in the government.
Now they have informed you,
Yes, Your Lordship. They informed me that they will be losing the petition. Your Lordship.
they will be
Losing the petition. It seems like they will withdraw the petition.
withdraw the petition.
Yes, Your Lordship. That's what I've been informed, but I'm not familiar about it, Your Lordship.
Okay, inform him. We will take it out after some time.
Yes, Your Lordship. Obliged.
For orders, item number 24.
Yeah, this Lordship. I'd like to mention on behalf of Inahali Lordship. If 3 weeks time you have granted to me Lordship.
You are for? Respondent number? Respondent number?
1, 2, 1, 2, 3, 4. 1, 2, 3, and 4 Lordship.
Heard, Miss? Madam, you? For
Grace
the
Sun.
petitioner, learned counsel for the petitioner, and Miss Sun, learned counsel. Appearing on behalf of
Miss Inahali.
Miss Inahole, learned counsel for the respondent number 1, 2, 3, and 4.
Yes, Lordship.
Office note dated 21/1/2026 indicates that service report upon respondent number 5 is still awaited. What to do? You want to take fresh step or will this?
I would like to take fresh step.
Fresh step. The learned counsel for the petitioner submits that she will take fresh step upon respondent number 5. Accordingly, it is provided that step be taken upon respondent number 5 by speed post and also by usual process within a week from today. List the matter after 4 weeks. After 4 weeks. In the meantime, learned government advocate shall file the affidavit in opposition for the respondent number 1, 2, 3, and 4.
Thanks, Lordship.
For orders, item number 25.
If I may, my Lord,
Yes,
this IA is filed to implement 1 T Longang Pontiac as per respondent number 6. At the time of filing the writ petition, the petitioner was not awarded this private respondent number 6 was appointed on land ownership basis. Since the petitioner came to know at a later stage, he have filed this IA to implement with the permission of this honorable court to implement the 3T Longang Pontiac and case SDO office Agway as private respondent number 6.
heard, Mr.
And Pakinwitabo.
Learned counsel for the applicant and Miss
Ayala Angel for respondent number 5.
for respondent number 5 and for respondent number 1, 2, 3, and 4, Mr. Learned counsel for the learned government advocate. This interlocutory application is filed by the applicant for implementing T Longang Konyak, MTS at the subdivisional agricultural office Aboy in the main rate petition number 164 of 2024 as respondent number 6. The learned counsel for the applicant submits that while filing the rate petition number 164 of 2024, the petitioner was not aware of about the appointment of respondent number 6, the appointment of Sri T Longang Konyak as MTS at the subdivisional agricultural office Aboy. And as such, he could not be implemented as respondent in the said rate petition. And in order to deal with the issue raised in the WPC number so and so, implement of Sri T. Langang Konyak is necessary in WPC number 164 of 2024. And accordingly, he has contended to allow this interlocutory application. Any objection?
No.
Ms. So-and-so, learned counsel, for the respondent number so, and Mr. So-and-so, for the respondent numbers 1, 2, 3, 4, and 5, submits that they have no objection in the event of allowing this interlocutory application. But having heard the submission of learned counsel for both the parties, I have carefully gone to the application and the documents placed on record, and it appears that Shri T. Langang Konyak is a necessary party in the WPC number 164 of 2024. And his presence is necessary. And hearing him is found to be necessary in order to adjudicate the issue involved in the said writ petition. Accordingly, this interlocutory application stands allowed. Shri T. Langang Konyak, MTS Subdivisional Agriculture Office, Aboy, being pleaded as respondent number 6 in WPC number 164 of 2024. In view of the order passed in this IA, now the petitioner shall file amended cause title in the WPC number 164 of 2024 within a period of 1 week from today.
Yes.
Sorry for interrupting, Lordship. I was on my foot in court number 2. Lordship, item number 16, mention was made that the matter will be taken up at 2, Lordship.
Yes.
Lordship, I have some personal duties. I have to attend to one family. Lordship, as far as item 16 is concerned, I'm representing the AG, respondent number 5, Accountant General Office. Here, Lordship, the matter is clearly between the state and the petitioner, because the issue involved is wrong fixation of salary. It was done by the state. So they have been directed to recover the salary, the wrong fixation, which has got nothing to do with me as AG. In fact, my junior will be assisting the court. So if I may be.
Okay, you can go.
Lordship. Because as far as I've given instruction to my junior, mentioning on that line, Lordship.
Okay.
Because I have no role to play. Because it's purely with the state and the petitioner.
Okay.
I'm deeply obliged, Lordship.
Mr. Lordship, I cannot communicate with the petitioner, so I waited if this matter could be passed over or listed on Thursday, Lordship.
Thursday.
Yes, Lordship.
Mr.
Jin Yang Pong, Your Lordship, for response.
Item number?
Item number 23, Your Lordship, orders from orders list.
23, learned counsel appearing on behalf of Mr.
Gauhati CGC.
Gauhati, learned CGSC. Price for listing the matter on
Thursday.
Thursday.
Yes,
Fair load. Let's list the matter on Thursday.
Obliged.
For hearing, item number 32.
I think the state is represented by the learned AG in Kingston.
Is he present?
Yes, he was present. He's present. If there are any
Okay,
matters to be taken up, then that is. If there are any other matters to be taken up, that may be taken up first.
No, we have no other matters for us. Okay, inform him.
Very well. Lord Smith.
I'm sitting here for something.
All right. In this matter, the petitioner is raising the question as to whether why the state should not file a civil suit and instead resort to the summary procedure for evicting the petitioner under the Nagaland unauthorized eviction of persons from unauthorized occupation act, which is in parametry with the Central Public Premises Act. On the ground that the state has not produced any positive title to show that the land in question belongs to the state. That's the primary issue in this petition. Now, the impugned order, page 26. This was issued under Section 5 of the Nagaland Eviction of Persons in Unauthorized Occupation of Public Land Act. On the ground that on the alleged ground that the petitioner was in illegal occupation of government quarter number CH/TP1 belonging to Directorate of Urban Development, Nagaland, Kohima. This was issued under Section 5(1) of the said Act. And accordingly, the petitioner furnished his reply at page 27.
Page number 50.
27. 27 is the reply of the petitioner to the show cause notice. Page 29 is another reply to the show cause notice, and this was submitted by the vendor from whom the petitioner bought or purchased the land in question. On the ground, now this, if I may be allowed to read the content of this, page 29. This was submitted by the original ancestral landowner, page 29. May I be allowed to read the content? Subject regarding land and quarter located at Lower Chanbai, Kohima. With due respect, I have the honor to state that the land as stated from the above subject sold to and occupied by Dr. Toshi Manan Ozakan, that is the petitioner, retired HOD Directorate of Municipal Affairs since 1998, has never been sold to Urban Development Department nor taken any compensation by Metro Quarter. There is no record of land allotment to the department and no record of civil deposit work given to the PWD department for construction of the quarter and handing over to Urban Development Department as replied to the RTI queries. Meanwhile, the PWD department has surveyed the quarter constructed in 1967 and found that the quarter has outlived its life and rotten beyond economic repair. Further, I wish to clearly state that the land in question does not belong to the government, as the erstwhile education and urban development vehicle garage on the above quarter and the industry department vehicle garage adjacent to the quarter, as well as the open space kitchen garden of Commissioner Department 2 quarters below the quarter in question, have been reclaimed by my clan, as there was no compensation over the land. As such, now all the land belongs to private individuals who have purchased from my clan. Furthermore, the Urban Development Department, which is claiming the quarter, has agreed to exchange the 54 years old outdated building with a new building of same type 5 to construct by the family of the petitioner in the department land in Bere Colony, Kohima. I therefore request you to issue no objection to the agreement. Now, this was the reply submitted by the vendor, the original ancestral landowners, for whom the petitioner purchased the land in question. Now, if you lordship, the admitted fact is that sometime in 1997, as stated in my petition, the petitioner, yes, he was an employee of the then Chief Town Planner. It was earlier called Chief Town Planner, now it's the Urban Development Department. He was an employee, and when he was posted here in Kohima, sometime in 97, at page 31, he was allotted this quarter. Page 31. On page 32.
So it is not in dispute that it was a quarter earlier.
Yes, it is not in dispute. The quarter already existed in 67, as I also enclosed the document, and he was allotted this quarter. It is not in dispute. But the question is whether prior to the allotment, whether the land legally belonged to the state. Now the state has come with the stand that it belonged to them. Now it's onus on the state to establish that there was a title, because if they want to invoke the summary proceedings under this, if I may be allowed to refer to it as the Eviction Act, under this Eviction Act, there has to be a positive evidence to show that yes, the land clearly belonged to the government. Now, the contention of the petitioner is that in view of the disputes raised in this petition, the state ought to have filed a civil suit and establish the title. Now, that's the primary contention. Now, therefore, the admitted fact, it's admitted that yes, they has to. And by an order dated 27 May 1998, page 32, was the type copy only. It was awarded. Now, at page 33, the Lordship may have page 33. This was a survey conducted by the GWD department, and here, by this letter, they found that these are the 4 points. They found that the quarter number CHTP1 is on the building register book. It's type 5, and it was constructed in the year 1967. Now, this is also admitted as on record. Now, prior to the allotment, the Lordship may have page 30. Prior to the allotment.
Page number?
30. The petitioner, he purchased his 2 parcels of land. Again, it's this. Yes, Your Lordship will see that on page 30, the petitioner purchased 2 parcels of land. These 2 plots of land, it falls in the same subject land that we are concerned with here in this petition. Again, this was purchased from we call it the Tsutyonyome Youth Organization, or in short, this is a TKL of Kohima village, one of the KLs of Kohima village who are the original landowners, and so far as this area of land is concerned. This also is in a subject land. He purchased this land. This was prior to the allotment, 16/3/1998. This is the existence of this, the state does not deny. Thereafter, at page 34, this is also another sale deed where the petitioner has purchased another portion of the subject land in question. Page 34.
Yes.
Yes. So this was also another part of the subject line in question, which the petitioner purchased from the landowner, that is from the TKL, and who replied to the deputy commissioner, which I earlier read out. That is the concerned person is this K. Bello. Now, despite the submission of the reply of the petitioner, at page 36, the impugned eviction order was issued under section 6(1) of the Act, and the petitioner was directed to be evicted. Now, if your Lordship may notice that the schedule of the land has not been mentioned, except even in the section 5 notice, the Lordship will see that the schedule has not been mentioned, except to merely state the quarter number. Now, even here is eviction order, the schedule has not been mentioned, the schedule of the land. Now, therefore, the claims of the state insofar as the land is concerned is not clear from the records, except to merely state the quarter number. Now, pursuant to the direction for eviction passed by the authorities, the petitioner has preferred the appeal under section 12 of the Act, and the appeal was also dismissed. Now, the order of the commissioner. Before that, now during the pendency of the appeal, the petitioner had filed some RTI queries before the concerned officers. Now, the responses of the RTIs are relevant insofar as the petition is concerned, so I may be able to take the Lordship to some of the replies submitted by the authorities. In the first RTI, which I've enclosed as Annexure P8 at page 45, the queries are, there are 3 queries in this RTI application. And the query pertains to whether, number 1, the government of Nagaland has acquired any land in Lower Chanmari, Kohima. If so, what is the total area? And whether land compensation has been paid to any of the landowner whose land has been acquired by the government of Nagaland, and whether your department, that is this was addressed to the Deputy Commissioner, has issued any land allotment order and land pata to the Urban Development Department in Kohima. Accordingly, the Office of the Deputy Commissioner furnished their reply at page 47. And in reply thereof, the office says that in number 1, yes, the government has acquired the land in Chanmari area. Number 2, as per this office record, the government of Nagaland acquired 9.05 acres of land at Chanmari. Now, the map has not been enclosed, but in the next page, at page 48, I have the type copy at page 49. Page 49, the type copy. These are the landowners from whom the government apparently purchased. And these 2, they are not the landowners insofar as the subject land is concerned in this petition. And also, the acquisition date will go back to 1971. Page 49, the type copy. Lordship will note that the acquisition date is 5/7 in the month of July 1971. Whereas in this case, apparently a quarter has already been constructed. Whether the land has been acquired or not, that is disputed. But a quarter already existed prior to the acquisition, as provided in the RTI response. And furthermore,
Whether you can raise this issue now that it was not acquired from the original owner.
Yes, of course, Lordship, because
And the original owner is not allied as a party in the
yes, of course, I can raise it because 300A is involved directly involved in this case. Now the original, that's why I've taken your Lordship to the reply application submitted by the landowner, stating to the effect that their land, ancestral land, was never acquired. Lordship may also know that this was in the year 1967. Apparently, there's a record which says that the government quarter was already constructed. But your Lordship may note that Nagaland attained its statehood only in the year 62. Now, this was afresh. Now, I do not have at the moment with me, but there are official documents stating to the effect that quarters were constructed on lands without being acquired. Now, I do not have that at the moment, but that is there in the official documents of the government, where quarters were constructed nonchalantly in lands which were not acquired. Now we are concerned with one colony. There's another colony we call Merulietsa, where the government has admitted that quarters were constructed. And during this post the statehood, immediately, when everything was fresh. Now, therefore, I'm bringing your Lordship's notice to this acquisition date 71, whereas the quarter construction predates this. And in the response also, the DC further states that at page 47 again. At point 4, as per office record, there is no land allotment order issued to Urban Development Department in Kohima town. However, the land pata has been issued at PR Hill. Now, this is another colony which we are not concerned with. The colony that we are concerned with is the Chanmari colony. Now, again, if I may take your Lordship to another query sought by the petitioner. At page 52. Page 52.
Yes.
Yes. Now, this was addressed to the concerned department that we are involved with, the Town Planning Works Division, the Executive Engineer. Now, the queries 1, 2, 3, and 4, I will not be reading out, but the response is relevant to the petitioner. At page 54, this was the response submitted by the department itself, that is the Urban Development Department, at page 54. Your Lordship may have the serial number 3. Whether your department has spent any amount in the construction of boundary wall, renovation, and rewiring of the government quarter number CHTP1, type 5 in Lower January. If so, please provide a photocopy of the expenditure voucher. Now, the reply says that there is no such quarter number CHTP 185 in the building inventory list of Urban Development Department. Now, when the department itself has admitted that they do not have such quarter in their building inventory list, there was no basis.
No, Mr. Iralo, you see, you have admitted that there was a quarter
Yes,
and you are an employee of that department.
yes,
That quarter was allotted to you, you have resided there, you have constructed the same. And now you are claiming ownership of the same,
yes, but
raising the issue of ownership of the land.
yes, no doubt those facts are against the petitioner.
Mm.
But admission, your lordship very well knows, admission does not confer ownership on the local government. Admission will never confer ownership.
No, that's
Now,
all.
when the government proceeds to invoke the summary
But
proceeding-
do you have the locus to question the ownership of the land?
Yes, because my primary ground is that when the government proceeds to invoke the summary proceedings under the Eviction Act, the settled law is that there has to be a positive evidence to show that they have a clear title to the land. In the absence of which, the government, yes, they may be able
No.
to prove later on. But it is,
You yourselves in your petition admitted that you resided in the quarter
yes,
belonging to that department.
yes, but the quarter and the land, it cannot be segregated. The lordship will know very well that it cannot be segregated.
Mm.
Now, therefore, if the government desires to evict the petitioner, they have
No, and the question is whether this court can decide the title of the land now.
no.
Then
But this being a matter of 300A, I'm submitting that the government ought to have filed the suit and proceed to evict me. Oh. But they could not have resorted to the summary proceedings under the Eviction Act. That is the primary case of the petitioner. No doubt some facts are against the petitioner. But in view of the statements made by the landowners, who will come before the court to depose later on as to whether the land has been acquired, the land in question has been acquired, that my humble submission is that this court has to look into that. Because the state proceeds to invoke the summary proceedings. Now, may I continue with my submission? Now, the Urban Development Department, they themselves has admitted that there is no such quarter in a building inventory list. And when there is no such quarter in the building inventory list, there was no basis for the department to have invoked the summary proceedings under the Eviction Act. That is one of the grounds which I'm taking in the petition. Now, furthermore, the petitioner has also submitted inquiries before RTI inquiries before the housing. I'll not be reading them out, but at page 57. Page 57, if you lordship may kindly have.
yes.
Again, this in serial number 1, the quarter number here. The state is also not sure which quarter they are claiming. Here, the state refers to, even in their affidavit also, your lordship would see that another different quarter number, UDCH 157. Now, we are not concerned with the CHTP 1, but the state themselves in their affidavit, they have stated that the UDCH 1 quarter. Now, they are not sure which quarter they are also claiming. Now, therefore, this prompted the petitioner to file an RTI application seeking query as to whether there is any quarter. And then the response being in the negative. And if your lordship may also have at page 59. Page 59, this was to the electrical division, the executive engineer of the electrical division. Query number 2, whether there was any electrical connection to quarter number so and so, the concerned the quarter in this petition. He said that there is no such electrical connectivity to this quarter. And in the same manner, regarding the water connectivity, it's in a negative at page 61. So, I mean, this replies, page 61, there is no water connection to the above mentioned quarter. Now, the very existence, yes, there was the executive engineer report which says that there was a quarter which was constructed in 67. But then the contemporaneous records which are found in the other departments of the government, it speaks otherwise. Therefore, the RTI, the responses submitted by the various officers in the RTI applications were submitted to the commissioner, the appellate authority, but then the appellate authority had proceeded to dismiss the appeal as well. Now, in the impugned appellate order at page 69, page 69. The appellate authority failed to consider the questions which were raised by the petitioner in his appeal memo, which I'm also raising here in this petition, to the effect that the quarter and the land, insofar as the quarter on which the quarter stands, cannot be segregated. Now, in view of the fact that, in view of the self-position, that if the state proceeds to invoke the cause of repetition, the summary proceedings under the Eviction Act, they have to establish or show that there is a clear title on the land, in the absence of which the state ought to have proceeded to file a suit for declaration of title as well as the eviction of the petitioner, which was not done. And therefore, the primary case of the petitioner, insofar as this petition is concerned, is that the
No, you tell me one thing. Do you have any document to show that the land belongs to you?
yes, the sale deeds which I referred to.
Sold it.
Yes,
When it was executed?
98.
19?
At annexure March 1998, which was the first one, is the petitioner bought.
Annexure number?
Annexure, there will be an annexure 5.
Annexure 5.
The two sale deeds, annexure P5, sorry.
P5.
P5 and
And when the quarter was allotted to you?
so first, prior to the allotment, the allotment order is 1998 of May.
98 of May.
Yes. Prior to the allotment order, there's also another sale deed which I've taken your lordship to at page 30. This precedes the allotment order, the sale deed of 16 March 1998. Page 30.
Page?
30.
That page 34 is the sale date. It is on 12th day of February 2015.
Yes. That's one sale date. And then the other one is page 30, 16 March 1998.
Then how the quarter came to be constructed on that plot of land?
That is why, as far as those aspects are concerned, except for the document which I've taken your lordship to, stating that it was constructed in 67, insofar as the RTI reply submitted by the petitioner has not evinced any response from the concerned departments. None of the departments. They have submitted any replies to how it was constructed, when it was constructed, whether the land was acquired prior to the construction. So those, the submission is that those has to be established by the state before they proceed to invoke the Eviction Act. That is, in short, the contention of the petitioner, because in view of the existence of the sale deeds, where the landowners themselves have fully surrendered the ownership to the petitioner, the state has to challenge that. Now, the state relies on, if I may take lodge to the state's affidavit.
Yes.
Lordship, can you give me? Page 26, 27, my friend, 27 of the counter affidavit. This is one of the bases for the state. Now, this, if the Lordship may note, the content, it reads as follows. It has come to the notice of the authority that some private individuals are claiming land within 1934-35 settlement map of Kohima and selling plots to individuals. It is therefore hereby informed to all general public that no private individual should claim land within 34-35 settlement as private land. Anybody who are purchasing land from so-called landowners will be at their own risk. Now, this 1934-35 map, here we refer to it as the British map. Now, this map was constructed when the Kohima was under British annexation. And based on this, the state claims that lands which fall under this 34-35 settlement map, it belongs to the state government. Now, however, the petitioner is raising a contention to this effect that if at all the 34-35 settlement map was to operate in view of Article 294, may I take a lordship to 294 article of the Constitution? This is the article which will govern the properties which vested with His Majesty pursuant to the coming of the Constitution, 294. Succession to property, assets, rights, liabilities, and obligations in certain cases. As from the commencement of this Constitution, all property and assets which immediately before such commencement were vested, I'm emphasizing on the word vested, in His Majesty, for the purposes of the government of the Dominion of India, and all property and assets which immediately before such commencement were vested in His Majesty for the purposes of the government of each governor's province shall vest respectively in the Union and the corresponding state. And all rights, liabilities, and obligations of the government of the Dominion of India and of the government of each governor's province, whether arising out of any contract or otherwise, shall yield the rights, liabilities, and obligations respectively of the government of India and the government of each corresponding state. Now, the primary word used in this article is vesting. The land has to vest with His Majesty, and pursuant to the coming of the Constitution, such lands which vested in His Majesty would vest in the appropriate government, be it the central or the state. Now, for a land to vest, with the appropriate government under the law, the Land Acquisition Act, 1894, it has to be followed. Lands has to be acquired under Section 11, under the Acquisition Act, and the land has to vest under Section 16 of the Act. Now, may I take lordship to the
No, Mr. Irano, you say basically in this petition you are challenging the order passed by the appellate authority.
Yes.
Right?
Yes.
But here, can you raise all those issues while we are testing the correctness or otherwise of the
Yes, no,
order passed by the appellate
Yes,
authority?
those issues, it has to be raised before the trial court, but I'm raising these issues because to show this court that the state does not have a clear title to the land. And therefore, if they want to evict the petitioner at all, yes, they can resort to the remedies available in law, but not under the Eviction Act. They have to file a suit. They have to show the court that the subject land vests with the government as per the law, and therefore they have the authority to evict the petitioner. That has to be the stated cause for the state. They cannot resort to summary proceedings under the Eviction Act, which the Supreme Court has clearly stated. And therefore, in this regard, that is my short case only. I may be allowed to rely on some citations to support my contentions.
of the 11 citations. First is 1971 2 SEC 152, paragraph 6. Here also all the authorities are relying on deals with the Public Premises Act of various states. Now this we are concerned with Madhya Bharat as it then was, paragraph 6. The central question in these two appeals, that it is whether the state of Madhya Bharat ever became entitled to those properties in the facts and circumstances mentioned, which justified its attempt to evict the respondents under the provisions of the Act of 1952. This would depend on the finding as to whether these properties were taken over by the Union of Madhya Bharat following the merger of the state Jhabua therein in 1949. The fact that some only of the properties set forth in the Declaration of April 1, 1948 and claimed by the ruler as private property were accepted as such by the government of Madhya Pradesh does not lead to the inference that all the other items of property in the said declaration were taken over by an act. I'm relying on this portion. There must be some positive evidence of such act. It is also possible that the list had wrongly included properties belonging to citizens of the state of Jhabua, about which there was no adjudication. The records only show that out of the list of properties submitted by the ruler, a certain number of them was treated by the government of India as being his private properties. There was no finding with regard to the others that they appertained to the ruler as distinct from his private property. As these properties originally belonged to the predecessors in interest of the respondent and the respondent in so and so, there must be some evidence of displacement of their title before the Eviction Act could be made applicable to them. In order to succeed in the appeals, the appellant, that is the state, must first establish that the properties had been confiscated by the ex-ruler and had ceased to belong to so-and-so or Bapu so-and-so. Next page, Lordship. Next page. I'm reading from the fourth line from the top. Fourth line from the top. When attempts are made to deprive a person of his lawful inheritance, it must be shown by irreproachable evidence that the person in possession ceased to have any interest therein at a particular point of time, and that by some process of law the property vested in a person seeking to eject the former lawful possessor. There is no such evidence in this case. It follows that the properties, the subject matter of the two appeals, never became the properties of the ruler of Jhabua, ownership whereof passed to the Union of Madhya Bharat, and from the Union to the state of Madhya Pradesh. Section 3 of the Madhya Pradesh Premises Eviction Act 1952 enables the competent authority under the Act to order inter alia that the person in unauthorized occupation of any government premises to vacate the same within 30 days of the date of the service of the notice in terms of the section. Section 4 empowers the competent authority to assess damages on the ground of use and occupation by any person in unauthorized occupation of any government premises. In order to enable government to take proceedings successfully under either of these sections, it must satisfy the court that the premises in respect whereof action was taken was government premises. As the state failed to establish this fact, the question of eviction under the Act could never arise. Now, this is one of the first authorities. Now, the second is 1982 2 SCC 134. 1982, I'm relying on paragraph 5, 6, 8, and 10. Paragraph 5, may I read?
Yes.
5. On March, I'm also reading some of the facts just to give the background. On March 19, 1974, the respondents filed writ petitions in the High Court of Andhra Pradesh challenging the order by which they were evicted from the plots summarily under the provisions of the Act of 1905. The learned single judge dismissed those writ petitions, observing the question whether the lands which we are concerned in the writ petition were acquired by the government or not, and the question whether the government had transferred its title to the university or not, are questions which cannot be properly decided by me in an application under 226 of the Constitution. The appropriate remedy for the petitioners is to file a suit to establish their title. Paragraph 6. Now, against this decision, the appeals were preferred. 3 appeals were preferred to the division bench against the judgment of the learned single judge, 2 of them being by the petitioners in one writ petition and the third by the petitioner in the other writ petition. The division bench, while setting aside the judgment of the learned single judge, held the question whether the lands belong to Osmania University or not will have to be decided as and when the government comes forward with a suit for the purpose. Now, this I'm relying on is because it has to be the government who has to file a suit, not the other way around. Even if we assume for the purpose of our judgment, as we are not pronouncing any conclusion as to whether the land vested in a government or university, the government is the owner, the dispute going back from 1942 cannot be dealt with in a summary proceedings under Section 7 of the Land Encroachment Act. Now, the next paragraph 8. Paragraph 8. It seems to us clear from these provisions that the summary remedy for eviction, which is provided for by Section 6 of the Act, can be resorted to by the government only against persons who are in unauthorized occupation of any land which is the property of the government. In regard to property described in subsections 1 and 2 of Sections 2, there can be no doubt, difficulty, or dispute as to the title of the government, and therefore, in respect of such property, the government would be free to take recourse to the summary remedy of eviction provided for in Section 6. A person who occupies a part of public road, street, bridge, the bed of the sea, and the like is in unauthorized occupation of property, which is declared by Section 2 to be the property of the government, and therefore, it is in public interest to evict him expeditiously, which can only be done by resorting to the summary remedy provided by this. But Section 6(1), which confers the power of summary eviction on the government, limits that power to cases in which a person is in unauthorized occupation of a land for which he is liable to pay assessment under Section 3. Section 3 in turn refers to unauthorized occupation of any land which is the property of the government. If there is a bona fide dispute regarding the title of the government to any property, the government cannot take a unilateral decision in its own favor that the property belongs to it, and on the basis of such decision, take recourse to the summary remedy provided by Section 6 for evicting the persons who is in possession of the property under a bona fide claim or title. In the instant case, there is unquestionably a genuine dispute raised between the state government and the respondents as to whether the 3 plots of land were the subject matter of acquisition proceedings taken by the then government of Hyderabad, and whether the Osmania University, for whose benefit the plots are alleged to have been acquired, had lost title to the property by operation of the law of limitation. Now, these questions are raised, and next, lastly, on paragraph 10. The conspectus of facts in the instant case justifies the view that the question as to the title to the 3 plots cannot be appropriately decided in a summary inquiry contemplated by Section 6 and 7 of the Act. The long possession of the respondents and their predecessors in title of these plots raises a genuine dispute between them and the government on the question of title, remembering especially that the property admittedly belonged to the family of Nawab from whom the respondents claim to have purchased it. The question as to whether the title to the property came to be vested in the government as a result of acquisition, and the further question whether the Nawab approached upon that property thereafter and perfected his title by adverse possession must be decided in a properly constituted suit, maybe that the government may succeed in establishing his title to the property. But until that is done, the respondents cannot be evicted summarily. Now again, another authority. 1995, Supplement 2, SCC 290. Supplement 2, SCC 290. I'm relying on paragraph 6 to 9. I'll just read out the line for brevity. In the circumstances it is held, paragraph 9. Your Lordship has it. In the circumstances, it is held that the proceedings under Section 91 of the Act could not be validly initiated against respondent number 1, and as a result, the orders that have been passed in these proceedings by the Tehsildar, the Collector, and the Revenue Appellate Authority, and the Board of Revenue are set aside. The impugned judgment of the High Court, insofar as the order of the Board of Revenue dated, is maintained, but a further direction confirming the order of the Revenue Appellate Authority dated so and so is set aside. The findings and observations of the High Court in the impugned judgment of the matters in controversy between the matters also said it will be open to the state of the appellant. Again, this appeal was filed by the state. It will be open to the appellant to pursue the appropriate remedy available in note before the competent forum for establishing its rights over the land in question. Now, on the question of vesting, allow me to rely. I will not be reading out, but just one authority, 2010 8 SCC 467. 2010 8 SCC 467, paragraph 13, 15, and 16. The 13, 15, and 16. The meaning of the word vesting has been considered by this court time and again. in so and so, so and so, this court held that the meaning of the word vesting varies as per the context of the statute in which the property vests. While considering the case under Section 16 and 17 of the 1894 Act, the court held as under paragraph 19, the property acquired becomes the property of government without any condition or limitations, either as to title or possession. The legislature has made it clear that the vesting of the property is not for any limited purpose or limited duration, and further goes on to explain in paragraph 15 and 16 as well. Now, therefore, it is one of the contention of the petitioner that this land, this subject land, has never vested with the government in accordance with Article 294 of the Constitution. Now, another authority is from our own bench, and the division bench, reported in GOT 2017 1 GOT 660. Is that in the compilation I enclosed, Your Lordship? 2017 1 GOT?
That is not here. These are all Supreme Court decisions.
No, that's for the same point, to the effect that, in view of the fact that if the land has to, the state has to show that the land, the subject land vests with it if it was to invoke the summary proceedings under the Eviction Act. Now, the last authority is 2019 2 SCC 327. 2019 2 SCC 327. I'm relying on paragraphs 2, 3, 5. I will not be reading them out, but again, in view of the disputed questions of fact, and the state having failed to establish, to show the court that it has its title to invoke the proceedings under the summary, to invoke the summary proceedings of the Eviction Act, the Supreme Court at paragraph 5 gave liberty to the state to file a civil suit. Here also the appeal was filed by the state. Having heard the learned counsel for the parties and our own perusal of the records of the case and the written submissions filed by the appellants, we are inclined to agree with the observations made by the High Court in the impugn order. In our opinion, keeping in view the nature of the factual controversy raised by the parties before the estate officer, the proper remedy of the appellants would be to file civil suit against the respondents for their eviction from the properties under the general law rather than to take recourse to the summary remedy of eviction provided under the Act. Now, while I'm at this,
We'll take a break, 5 minutes.
What's this?
section 2H at page 2. 2H.
Yes.
The definition is provided. The land, public land means land, any land belonging to or taken on lease by state government or local authority or government so on and so forth. And therefore, in view of the jurisprudence insofar as the public premises is concerned and on what basis the state is to invoke the summary proceedings, there has to be a positive title to the effect that the land clearly belongs to the state government, where under which only, that's the primary basis, that's the root of the, for invoking the proceedings under the Eviction Act. And only on the basis, only then the eviction proceedings can be initiated. Now in this case, except to rely on one notification, which is also not in contrary with Article 294 of the Constitution, the submission is that the state could not have resorted to this act except to file a suit. Now if the state files suit, they may be able to establish a title, but until and unless they do that, the summary proceedings, in view of the settled position, the summary proceedings under this act cannot be resorted to. That is the primary submission to petitioner. Now, regarding the Land Acquisition Act, you also may have Nagaland Code Volume 1, just to show that it was applicable. When the state was formed.
No. If you have purchased the land prior to construction of the quarter, then where is the question of entering into the quarter by you?
No, the come again, you know.
If you have constructed if you have purchased the land prior to construction of that quarter, then where is the question of entering into the quarter? You ought to have constructed your residential building then and there.
Yes, I have stated my feelings that the entire quarter was renovated. Even the boundary was drawn by the petitioner himself. Therefore, I stated that earlier that the state is not clear the boundary of the petitioner also. Only after this, the entire dealings were done in the county affidavit, they come with a plan. Now the state is not clear because what the state produces here before this court will not be relevant because insofar as the proceedings under we are concerned with proceedings under the Eviction Act. Therefore, the documents have to be produced before the evicting authorities. None of those documents are produced. Given the notification, of course, that this court can take judicial notice of. But even for the notification to apply, the submission is that the state has to be, the land has to vest. Because the word vested or vesting has been used in 294. That it has to be vested. It has to be vested with state government. The state should establish that. And that is why the Supreme Court keeps on insisting that if the state wants to resort to these proceedings, then they have to, by a clear positive evidence, show that the land vested. Now, yes, despite the existence of the quarter, my submission is that the presumption of land ownership cannot be there, despite the existence of the quarter. The state has to show by clear proof that the land belongs to the mere existence of the quarter on that land will not give any benefit of presumption to the state. And there is also another contention. Now, just for your lordship's reference only, lordship may have to contend. Serial number 8 list of central acts in force in Nagaland.
Serial number
8 of the content.
List of central acts.
Yes. Now these are the list of central acts which were in force in Nagaland at the time they contained in statehood. And at page 436. 436, lordship will see in the second last segment, 1894, the Land Acquisition Act in force in Kohima and Gauhati districts. Just to show your lordship that this act was in force.
Which
Under
one?
The 1894 Land Acquisition Act. Page 436.
Yes, yes.
The second last, 1894. Lordship responded. Page 43.
436.
Yes.
The Assam. No, no,
Lordship,
this
I
is
have
a
a
different.
version of this. My lord can come directly to page 436.
Yes.
The second last, it will show that the 1894 Land Acquisition Act was applicable in Kohima, in addition to Mokuchin. And therefore, the vesting has to be done in a manner known to law. That is what, in my submission, Article 294 prescribes. Vesting has to
No,
be
no.
done in
Is it your contention that this act is not applicable?
No, no. I'm saying that this was applicable, and therefore, if the state relies on the notification to be referring to the 1934-35 settlement map, then in that case, the acquisition act has to be applied. The state has to show that they acquired the land and invested with them as per the act, central act, and then only they can rely on 294 read with the notification to show that the land of His Majesty vested in the state. But then again, there's no document or map even in fact showing that the land, the subject land comes within the map. Therefore, again, another dispute is the state, of course, even before the evicting authorities, the state has not relied on this, only before this court, the state is producing this document. But therefore, even to this effect, I'm submitting that the state could not have resorted to the summary proceedings, but the state's only remedy is to file a suit. Now, they may succeed eventually, but until and unless they establish their title, they cannot resort to the summary proceedings under the Nagaland eviction, that is the primary submission. And therefore, my humble prayer is that the eviction orders passed against the petition may be dismissed, and where yes, liberty may be granted to the state to file a suit if so advised for the eviction of the petitioner. That is all I'm submitting. I'm not obliged, subject to what the state may say. I may be allowed. I mean, I seek.
Okay, okay. Yes.
Lordship, I need to take a clarification from the department. So, Lordship will be allowed to take up at 2. No, I'm not going to take much time. Within half an hour, I can complete my submission. By the time, at the same time, I did one clarification from the department. So, allowed to take up this matter at 2.
At 2, we have another matter. After attending that matter, we will. Okay. Okay.